think so, because the plaintiff, even in her own declaration, she states that she went to the office of counsel for Bank of America. She viewed what they...
You're talking about when she went to Davis Wright?
Yes.
Right, and she's saying that they gave her a copy that was in color, but it wasn't the original signature.
So she's disputing the quality of the disclosure. I think that's a step away from that it's a false disclosure. She doesn't agree with the disclosure. It doesn't mean that
her declaration about the Davis Wright, and no offense to that law firm, we're not trying to, at least I'm not trying to disparage them, but her allegation is that the document she received there was either a forgery or was a fake, or certainly not the original that they claimed it was. Why doesn't, for a 12b-6, why doesn't that survive? They've alleged more. They've alleged that you knew, not you personally, but your client knew that the documents that they were proffering, that the identity that they were providing was false. And it's that knowledge that bumps it into fraud.
That's why I think this is a claim that should be confined to the statute and not the subject of a fraudulent disclosure or a fraudulent concealment claim. We weren't concealing anything. We were passing on the information that was provided to us. That's what the statute requires.
Isn't there concealment allegation based on the allegation, at least, that you knew or should have known that the documents that they were disclosing were false or weren't the real ones, didn't disclose the real beneficiary, whatever those allegations might be, but isn't, and again, I'm not saying they're right.
I agree.
This is something that they would have to prove on summary judgment or at trial, but for purposes of the 12b-6, I have to assume that if they're making those allegations, that those allegations are accurate.
Listen, people come to public courthouses to watch these events, and I broadcast these events because these are issues of extreme public importance. Now, honest judges and forthright litigants and their attorneys don't care, and they welcome my presence. Now, I'll broadcast the entire hearing later this week, but for now, you can see how attorneys Salyer and Dubé hate my cameras, and that is because their guilty conscience has them all crossed up. At least her conduct was nowhere near as reprehensible as that of prior counsel Joe McIntosh, when on one occasion he and Luke Wozniak reneged on an agreement to allow video depositions and tried to threaten me with arrest. Okay, I told them in no uncertain circumstances to go to hell.
Defendants are attempting to take something and make it theirs that belong to the plaintiff. And the issue here is that the defendants, the trustee, is prohibited by law from bidding at the sale. There's no allegation or evidence that this defendant bid at this, there wasn't a selling in this case, but that they bid at any other of these sales. So we don't think that there's a viable claim for extortion either. Yeah, and the whole focus of the statute there is obtain, and if you look up the definition of obtain, it's acquire or take into one's possession. And that's not what the defendants are doing here. They're selling at a public sale a piece of property that either the lender or some third party, third parties come to these sales and acquire these homes, but the defendant's not acquiring these homes. And so all of the allegations about reselling and attempting to take these properties, those are based, we think they're just plucked from some other complaint. They don't have anything to do with the facts in this case. There's no specific allegation that either of these defendants ever bid at a sale, and of course the sale didn't occur in this instance.
And to the extent this was a non-judicial foreclosure, RCW 6124 is going to govern that procedure and provides the remedies to the homeowner in terms of how that's supposed to operate. So I guess one of the things that I'll hear hopefully from the other side on is why we should use a statute that it seems to me is trying to deal with a whole other area. And I appreciated reading in your brief, the court might be surprised to hear us talking about extortion in relation to trustees and banks. And people accuse banks of lots of things, and so I'm not that surprised that they want to accuse them of extortion, but in order for it to fit a statute that really wasn't crafted with this scenario in mind, it seems to me, and when we have a statute that specifically was crafted to deal with non-judicial foreclosures, it seems to me that's the appropriate statute to look at, whether or not there's compliance or a violation of the law. But again, I'll give you a chance to be heard on it. So I'm less concerned, frankly, with of all the things that I thought would be a more clean thing to deal with on a 12b-6, it was this first one. When we start getting into the Consumer Protection Act, we start getting into really factual intensive inquiries And on a 12b6, when I can consider even hypothetical facts, it makes it really hard for me to grant a motion. The thing that jumped out at me, though, was the address, the physical requirement. And we've got an address, we've got a phone number. I agree that, oh, I don't agree, but I understand your argument you're making is they can't do that while at the same time serving in this other role or having their attorneys that are serving two roles. But and I'll give you a chance to tell me what the law
Foreshadowing
is
is wonderful, thank you.
Yeah, but so anyhow, so that one I think that you've got a decent argument on.
Okay.
But a lot of the rest, it just seems so factually intensive, and we do have a how many page complaint? Goes with no offense to counsel intended, but you know the total filing, 97 pages for heaven's sakes.
I was channeling James Michener, Your Honor.
Yeah, well, I'm not even at the end of it here. 62 pages. So you know it's. There's a lot of both facts alleged and hypothetical facts created people that might allow certainly a CPA violation to exist.
I agree, and I think that our CPA violation, really we're looking at the physical presence requirement,
Okay.
and whether or not there is a potential claim. And there's two issues there, and you've articulated one of them for me. The second issue is that, of course, to the extent that there are facts that arose after her complaint was filed with respect to the office in Poulsbo and the moving of that office that was later the subject of the Attorney General investigation, that's not relevant here. It's not something that she could have been injured by. That's what the causation analysis is about. So we think all of the physical presence should be out as well.
Some other plaintiff might have that allegation, but since it didn't impact or didn't even take place until after all the events that are at issue, I agree it does seem to make it harder for Ms. Pooley to maintain that claim, despite the fact that I understand why it was included. So, all right, so I think I know. Any other part of your CPA claim that you were
No,
hoping
but
to
there
get
was
kicked
one
out?
other issue under the Criminal Profiteering Act that I want to make sure that we've disposed of.
Sure.
And the third issue involved the alleged filing of false instruments, and that isn't one of the statutorily enumerated predicate acts. And so, to the extent that the plaintiff is trying to rely on that, that's out as well. So
And I didn't see that in the response, but I might have
but
missed it.
it's in the complaint.
Okay, all right. So maybe that's a concession that that's not part of the Criminal Profiteering Act violation.
Your Honor, as I will point out, I look at Little Rico as a statutory a provision that is necessarily a bottle in which you contain claims, but rather is a guidepost to potential expansion. But I'll get to that.
Okay, sounds good. And then what else do we need to cover before I turn things over?
Okay, we have a motion against the fraudulent concealment claim.
Okay.
And the reason that I think that that is a legal issue as opposed to a factual issue is, as you know, there is a statutory scheme that deals with the trustee's obligations with respect to both disclosure and good faith. It's important for you to know, because the Clem case has been repeatedly cited here, that the statute was amended in 2008.
Okay.
The statute that the Clem case dealt with did have a fiduciary duty, and that's why the court repeatedly notes a fiduciary duty to exercise their duty of good faith, something like that. And that is cited by plaintiff. The concurrence goes on to observe that the statute had been amended and that the court was really dealing with the old statute. So my brief cites the new section of the statute, which expressly states that there's no fiduciary duty owed to the borrower, which in this instance is Ms. Pooley.
But there's still a duty owed.
A duty of good faith. And
Right.
so then
and for fraud, why do we only need a fiduciary duty? You don't need it for fraudulent concealment. You just need a duty.
well, you have two issues. You have either they have to plead and prove the 9 elements of a regular fraud claim,
Yeah.
and those haven't been pled here, reliance, right to rely, those sorts of issues. And so the other issue is there an affirmative duty of disclosure? The duty of disclosure comes from this fiduciary duty. And we say there is no fiduciary duty of disclosure. To the extent that there's any disclosure obligation, it's what's contained in the statute. And the statute simply says that the notice of sale has to identify the beneficiary. And the notice of sale here does identify the beneficiary. Now plaintiff claims that the beneficiary is incorrect, but the point is that the disclosure is made.
Doesn't the disclosure have to be accurate?
Well, we believe that it is accurate.
But isn't that a disputed fact?
Well, we don't think so, because the plaintiff, even in her own declaration, she states that she went to the office of counsel for Bank of America. She viewed what they...
You're talking about when she went to Davis Wright?
Yes.
Right, and she's saying that they gave her a copy that was in color, but it wasn't the original signature.
So she's disputing the quality of the disclosure. I think that's a step away from that it's a false disclosure. She doesn't agree with the disclosure. It doesn't mean that
Her declaration about the Davis Wright, and no offense to that law firm, we're not trying, at least I'm not trying to disparage them, but her allegation is that the document she received there was either a forgery or was a fake, or is certainly not the original that they claimed it was. Why doesn't, for a 12b-6, why doesn't that survive?
Well, because to the extent that somebody was proffering false documents, we were proffering all of the information that we could obtain from the beneficiary. The beneficiary told us it was the original note. That's what we disclosed.
But if that turns out to be wrong,
then I think what the statute says is if that turns out to be wrong, then the trustee has an issue with respect to its good faith. It doesn't have an issue with respect to whether or not it inaccurately or incorrectly disclosed information that was provided to it. So that's why I think this is a claim that should be confined to the statute and not the subject of a fraudulent disclosure or a fraudulent concealment claim. We weren't concealing anything. We were passing on the information that was provided to us. That's what the statute requires.
Isn't there concealment allegation based on the allegation, at least, that you knew or should have known that the documents that you were disclosing were false or weren't the real ones, didn't disclose the real beneficiary, whatever those allegations might be, but isn't, and again, I'm not saying they're right.
I agree.
This is something that they would have to prove on summary judgment or at trial, but for purposes of the 12b-6, I have to assume that if they're making those allegations, that those allegations are accurate. So if I'm assuming today, and today only, that your clients actually were being inaccurate in their description of who, or their identification of who the beneficiary was, and disclosed a document that was not in fact the real document, why isn't that fraud?
I don't believe it's fraud because we were simply passing on the best information that we had available to us.
Well, and if that's what all they alleged, I'd agree with you. But they've alleged more. They've alleged that you knew, not you personally, but your client knew that the documents that they were proffering, that the identity that they were providing was false. And it's that knowledge that bumps it into fraud land. Now, again, they've got to prove this up. But for today's purposes, I have to assume that that's completely 100% true.
I recognize your position, so.
Okay, so I'm glad but it's a good conversation to have because I wasn't quite sure I really understood, honestly, the fraudulent concealment claim that much at all, or really what it gets them, no offense. I mean, when they already have a potential allegation for the statutory violation, it's a little belt and suspenders, but that's, you know, that keeps things from falling down, so that's fine. What else do we have? We've got the
motions to strike, and I don't know if you want to take them up now or if you want to finish the substantive motions first.
Well, because I've got a jury back there that actually has a verdict, just to make my morning a little more complicated, and I've also got a 10 o'clock and then a 10:30 and an 11. We need to move things along a little bit. I want to hear from, they're not, technically I think you're right that those aren't appropriate allegations of a complaint.
Okay.
You could ask for, at any stage in the game, though, that you take judicial notice.
And the interesting thing is there was a motion filed back in September that you take judicial notice. We responded to it
and I didn't understand that motion and then it went away. Didn't it go away?
I didn't know how it went away. I moved against it and then it sort of...
They struck the hearing.
Yes, and so we didn't know.
So
and
when
if
it's
he
not done
withdraws
for
the
hearing,
motion, we deal with this all at trial or before trial.
Yeah, I mean, I think that, wait now, that's kind of the, in my view, some issues are more important than others. That's down there a little bit on the list.
Okay.
Let's see if we've got time. I want to give council time.
Thank you, Your Honor.
Yeah.
The court has in hand the the requirements of 12B, any conceivable notion. Unfortunately, at this juncture, this is an amended complaint, and as the court will remember, there was most of these issues were addressed to the court on the motion to amend. So this is in some ways a rehash of that motion to some extent. Many of the same allegations were raised. Too much discovery has already been done in this case, and much of that has been dumped into the amended complaint. We also have to take into consideration, as to some of these allegations, we have a new defendant. Be interesting to see what McCarthy Holthus, sister company to the current defendants, may have to say about some of these allegations. So I think that at this point, under 12B, we may be a bit premature. The flow between 12B and summary judgment, I think is real, but I think much of the stuff that is being talked about here, but for a couple of exceptions, really does fall into the summary judgment area.
Well, let's just jump in because I want to make sure that we've got the right rule that we're relying on. When you start relying on things outside of the pleading, it can convert a 12B6 into a CR 56 motion. I haven't felt the need to look outside of the pleading. So you're not making that argument that.
No.
Okay, all right.
I'm just recognizing that this would be a different procedure had this been a recently filed complaint. And I represented a couple of the judges up in Snohomish County a few years back when somebody filed some pleadings, some things against their property, for instance, and we had to do a quiet title. It was very embarrassing for those jurists. And, you know, they were clearly crazy claims, and clearly crazy claims, but it was still embarrassing. You still had to go through the process. Those are the sorts of things that 12B is intended to clean up. Now, the court has identified a couple of things, but it needs to be considered in terms of the Lyons case, decided October 30. And I bring this up to the court because counsel didn't cite it. And the Lyons case does, again, recite the duty of good faith. I do rely on Clem.
So we're talking, let's just try to be precise in which.
Sure.
Are you going to fraudulent concealment?
I am going to start, I think, with the move into fraudulent concealment through 9A. Because the court did want me to speak as to what is my client asking, why would she bring a Little Rico claim? Little Rico is still emerging for its application to civil actions. Yes, it is a criminal statute. That's why it's in Title 9A.
Yep.
But that doesn't mean that it need be bottled up when you have facts which indicate that there may be felonious activity that the Attorney General hasn't addressed yet. Lily White. This is a company that's already been investigated, and they've had to move their offices because they were found to be in violation of the statute. Now, what else is going on? Well, we don't know entirely. A counsel will be offended by the fact that I'm impugning the character of a company that she has been retained to represent. Get over it. I do that all the time. But the fact of the matter is that, you know, the claims that we're talking about have multiple impacts, multiple claims. The essence of the facts, however, suggest several claims. Now, the court made the reference to belt and braces. I'm not old enough yet to have to do that.
I certainly wasn't trying to infer you were.
Thank you. It's my birthday, so you know I appreciate that.
Yeah.
But the point is that the fact of the matter is that the same nucleus of facts can give rise to a number of claims.
Sure. No, I don't have any problem with that.
Not the least of which, and I suppose if the court is inclined to get rid of the 9A Little Rico claim, this courtroom discouraged and offended and defeated. No, because the same nucleus of facts gives us criminal conspiracy.
Well, you've got tons of other claims that are not even at issue today.
Well, I think that's exactly right.
Yeah.
Now, if this court does not want to take up the cross for the Little Rico Act and its expansion,
Appellate courts often do.
And I go there all the time.
Yeah.
And I have to recognize the fact that this area of law is emerging.
Yeah.
I mean, you know, the Lyons came out on October 30. We have the Trujillo case, which is on review. In fact, the Supreme Court in a recent order said we're not going to deal with Trujillo until we get Lyons all cleaned up. And that I expect to be in the next few days. We have other cases backed up. I've got 5 cases myself down at the Court of Appeals that are in the queue. So yes, this stuff is emerging, and for this court not to wish to take on that responsibility, I get it, and I respect that. However, I think the court needs to be mindful in terms of these claims on 12B. Factual basis that one could argue that the Little Rico Act might apply. That's all, because I do have, you know, civil conspiracy. I misspoke a few moments ago. I'm criminal conspiracy. I'm no longer a prosecutor.
Yeah.
Civil conspiracy and some of these others.
No, I'm with you. Well, can we jump ahead?
Yes.
Because my time is limited, to the CPA violation and looking at the facts as we know them at that time, not the facts that occurred after the foreclosure action began, all those things. They had the physical address and telephone number as required by the statute, didn't they?
No.
Why not? Solely because of the attorney-agent issue?
Well, yes, they have to be neutral. Now, here's the dilemma. When Quality Loan, as a sister company of McCarthy Holthus, not unlike Ralph Crabtree Olson and Northwest Trustee Services, although they try to keep their walls a little bit clearer.
Yeah.
They've still run into problems themselves on the same basis. It is McCarthy Holthus who was representing the very banks that is now paying the rent and phone bill for the independent agent of the company that's trying to throw my client out of her home.
Right, but the McCarthy folks aren't before us right now. The Quality Loan folks are.
Well, I think that you
Both
can't.
versions.
There are two pockets of the same pair of pants, and at this juncture, absent, because the complaint has been filed, we don't yet have the facts as to the exact relationship between the two companies.
But what we do know, what's not in dispute, is that the Quality Loan folks, putting aside M&H, had a physical phone number and address in Washington as required by law. They just did. I don't think there's any way to get around it. H&M, or M&H, may have problems that you just identified. They're not in front of me.
In fact, McCarthy Holthus is still paying the rent.
I don't care what they're doing today. What matters is what happened at the time that Miss Pooley's home was threatened with foreclosure.
They were doing it then too.
4 years ago or whatever this was. I thought the allegations, I didn't think the facts backed that up.
Well, there's 2 different issues. There's
Okay.
the issue, there's the alleged issue that there's commingling because of rent paying.
Yeah.
The movement occurred in January of 2014, so after this was all over.
Yeah.
Quality is now in a different building on a different floor, and there was a time where they were completely in 2, one was in Hillsborough and one was here in Seattle, but that's all after January of 2014. But the important thing is the admission that's in the complaint that's important, is the plaintiff admits that they had a physical presence. The statute doesn't require that it be independent. What the statute says is whether or not you have a presence here. And the statute says, or the cases have said that you can designate an agent to be your physical presence. And that's what was an issue in the Douglas case. In this instance, Quality was actually at the address. They simply shared it with M&H, and for a time M&H was paying the rent. but there's nothing in the statute that prohibits that. Now, he's going to have arguments about the good faith issue, and we can argue about those later on. But for today, it's whether or not we violated the physical presence requirement, as the complaint alleges, and we believe we did not. We had the physical presence that was required by the statute at the time of Ms. Pulley's claims.
And your allegations, back to you, counsel, are not inconsistent with what she just said.
My problem, Your Honor, and
You just think that there was a conflict of interest that...
No.
No.
In the Douglas case...
You want to give me a quick cite?
Yes, that's a unreported...
But is this the, when you say unreported, this is
It's a federal district court.
Okay. Oh, and you guys only are citing Lexis, aren't you? Because I only have Westlaw, so a Lexis site does me nothing. Give me the names and I'll just search it real quick.
Douglas, D-O-U-G-L-A-S versus Recon Trust, another company.
How do you spell just Recon, R-E-C-O-N?
Capital C-O-N.
Yeah.
All right, let's see if it comes up. I cited a lot of cases, so I'm sorry that I didn't get a chance to read all of them before this morning. So Douglas Recon Trust did not come up.
One S.
Yeah. R-E-C-O-N.
And then T-R-U-S-T, it's one word.
Oh, it's one word?
Yeah.
Well, I think it was well argued by both sides, as I've come to expect in this case. And here's how I come out on the RCW 98-9A issue, which is also, I guess we're going to call that the criminal profiteering aspect of it. And there's a case actually, State versus Strong. It's a Court of Appeals case from 2012, 167 Washat 206. And that dealt with extortion and what extortion is meant to get to. And what this says is if a prospective plaintiff, let me give you a page number for this. This is at page 219. If a prospective plaintiff threatening litigation has or reasonably believes he or she has a claim of right, or threatens litigation with a nexus to a plausible claim of right, the threat falls outside the scope of the extortion statute. And Washington law does not require that the claim of right be proved. So what this, in my view, is getting to, and this is dealing with the exact statute that we've got at issue, but in a criminal sense, not in a civil sense, is what is the point of extortion? What are we really trying to get at? And for there to be an extortion. And extortion is where there's no plausible claim of right and the only leverage to force the payment of money resides in the threat, where actual disclosure would be counterproductive and where compliance with the threatener's demands provides no assurance against additional demands based on renewed threats of disclosure. That's an inherently wrongful threat. And here what is missing is any allegation or ability to allege that the quality loan folks had no reasonable belief or claim of right in what they were doing. And whether or not they ended up being right about who the beneficiary was, or whether or not they ended up being right about a lot of things, to me, doesn't mean, though, that they still did not have at least a reasonable belief in what they were doing. And that's what really the case law is getting at in terms of a threat and extortion, because honestly there actually are First Amendment issues there in terms of your freedom of speech and what you're doing, and that's what the Strong case dealt with. I also think that under the 9A, that clearly we don't meet the definition of unlawful debt under 9A 82010 subsection 21. And I don't think that this is also meeting the definition of, what was the other part of it, of extortion as defined by 120 and 130, which then reference threat as defined by 9A 04110 subsection 28 A, B, and C, and allow a claim for extortion or for that criminal profiteering to survive in this case. So I'm going to grant the 12B6 as to that claim. I'm also going to grant the 12B6 as to the physical presence element of the CPA violation. It's clear to me that that they in fact, maintain a physical presence and have telephone service at the address as required by 6124.030 subsection 6. To the extent that there was any kind of conflict of interest there, or to the extent that there was any payments made by a third party or a different party, maybe even a co-defendant, there are no allegations that have been made or can be made, in my view, that that fact has caused any harm to Ms. Pooley as required under the CPA, and so I'm going to grant that motion as well. In terms of the fraudulent concealment, I agree with plaintiff on this one. I think the duty of good faith is what is going to save the day there in terms of the affirmative duty to disclose. So I'm going to deny the 12b-6 as to fraudulent concealment, and I'm also denying it as to any other. I think the main one that I've covered in granting on the CPA is the one I just granted. To the extent there are other CPA violations that they seek to dismiss at this stage, I'm denying that. And also in terms of striking the allegations under CR 12F, the allegations that are really at issue, while arguably immaterial under that rule of 12F, honestly, I don't think there's a point to strike them. What a judge does down the road, because the judge is the only one that can take judicial notice anyhow, is really going to be up to that judge. And whether or not the parties are sad with this news, but today is my last day on this case. I'm transferring to Harborview, and so I won't be on this case anymore. I'm going to leave that for the judge that's next assigned to this case to decide what kind of judicial notice that judge wants to take. But I'm not going to strike those allegations from the complaint. So, can you guys work on an order that's consistent with my oral ruling?
Well, the court is leaving the bench, so.
Well, I'm not leaving the bench. I'm just leaving this bench, and moving my offices up the street to Harborview. So I will be around. You guys can certainly just email it to me, preferably this afternoon would be ideal. It's pretty easy. You can even write it up if you want. Granting on the on the criminal profiteering, granting on the CPA as to the physical presence, in all other respects, denied.
We'll get it done.
Okay.
Thank you, Your Honor.
Good luck in Harborview.
Thanks so much. Ms. Pooley, you take care.
We've had recent cases like Lyons. That gives us a lot to work with. But this litigation is expensive, unpredictable. There's so many moving parts. But you know, we had a small win today, and you know, I take my hat off to these attorneys. Richard Jones, I'm very impressed, and we just keep plowing ahead. We're making progress.
Terrific. Thank you. Ms. Erickson, do you have a comment today?
I feel very happy about this. It was like just said, it was one step back, but several steps forward, I feel.
I do too.
Right. This is quite a win. Fraud is a great win. So, and it was, the judge said that it was well litigated by both sides, and that's what we need is pros and attorneys litigating every chance they can to fight this battle,
Yes.
so that the people can win in the end.